Thank you everybody for joining this entry in the Pac-12 Access to Justice series. You have tonight a team, a hopefully dynamic duo from the University of Arizona James E. Rogers College of Law that includes my very wonderful colleague Stacy Butler and myself, Chris Griffin. I am the Director of Empirical and Policy Research here at Arizona Law, and I will let Stacy introduce herself and get the presentation started.
Thanks, Chris. I'm Stacy Butler. I direct the Innovation for Justice program. We are jointly housed at both the University of Arizona College of Law and the University of Utah Eckles School of Business. And give me a minute, I will turn on my screen share, except the host won't let me. Okay, how about now? Are you seeing my slide deck?
Perfect.
Great. So I think we've covered this slide. Here we go. Here's what we're going to talk about today. I'll talk a little bit about I4J and what we do. We'll do a very quick overview of what the Utah Regulatory Sandbox is and talk about the medical debt research questions that inform this project and why it's in the sandbox. And then Chris will share his takeaways from the lab experimental portion of the project. So I4J is the first cross-discipline, cross-state, cross-institution legal innovation lab in the United States. We are a virtual social justice lab, so we operate entirely online to design, build, and test disruptive solutions to the justice gap. Students in the lab learn to work collaboratively across disciplines. To date, we've had 12 different graduate disciplines in the lab. They work with and within community. So from the start of a project all the way to the end, students are working with community members on all of that design, build, and test. They are thinking creatively about solution building. So we're working to put new ideas into the world that haven't been tried before. We're using a design thinking framework, but layering onto that a systems thinking methodology. And we are a virtual lab, so we use technology a lot, but an important lesson in I4J is to make sure the technology is being used effectively. And we want all of our students, as Chris will emphasize today, to engage in evidence-based evaluation of their work. There are 3 focus areas that project work we can talk about today really fits in this first one, which is leveraging regulatory reform to legally empower underserved populations. But we also do work on ensuring that justice sector technology works for low-income populations. And to the extent we are involved in tech-related projects, we're focusing on how tech can be a tool for policy-level advocacy. So this is our team, and we're very, very proud of this team, all of them working very hard behind the scenes to make I4J happen. So Utah's Regulatory Sandbox, which is really the background for this project, this is generally probably not news to anyone. This is how the practice of law is typically regulated. In Utah, there's a state bar, they create rules of professional conduct, and then they license both lawyers, and in Utah there are LLPs, which are licensed paraprofessionals providing legal services. There's also this separate service track of the sandbox. So the Utah Supreme Court has an Office of Legal Services Innovation, and new types of legal services come into the sandbox as long as they report to the sandbox, which is engaged in risk-based regulation. And this opens the door to non-traditional forms of legal services and providers. The way the sandbox operates is to regulate based on risk. So the more lawyer work you have involved in your sandbox project, the lower risk you are, the less reporting you have to do. As you move away from lawyers providing legal services into non-lawyers or software technology providing the services, the risk increases, as does your data reporting. So players in the sandbox could include traditional law firms that are using non-lawyers or technology to deliver their services, legal tech startups, new offerings. This hasn't happened yet, but there's a lot of speculation where we see legal services in the lobby of Walmart. And what we're really interested in I4J is this idea of community-based organizations being able to use regulatory reform to embed legal advice in their frontline social services. I4J was really interested in working on a Utah sandbox project because we already have a project like this running in Arizona. In partnership with the Arizona Supreme Court, our licensed legal advocate pilot is training non-lawyer advocates at a DV shelter to give limited scope legal advice to survivors. This is the first pilot in the country to permit non-lawyer legal advice in the nonprofit sector. So the research question that we'll talk about today is, what are the barriers and challenges that the social service sector will face if they try to leverage the opportunities afforded by the sandbox? And what might we do to overcome those obstacles and advance access to justice? More specifically, we're interested in the organizational features that encourage nonprofit incorporation of non-lawyer services, the qualities that can encourage and sustain user participation in receiving non-lawyer advocacy services, the qualities that will promote collaboration between non-lawyer advocacy services and traditional legal services, or at least reduce the risk of crushing opposition from traditional legal services, and then finally what the opportunity spaces present as strong qualitative indicators of support. So why do we care whether nonprofits get in the sandbox? Generally, what we see when we talk about legal services for the low-income community is that legal services come too late to too few, and they aren't a viable pathway to problem solving. So in this project, where we're focused on medical debt, we know that most people disengage with their medical debt long before it reaches the civil legal system. In Utah, 72% of the medical debt cases involve a default. We also know that in general, this is a national statistic, 86% of our low-income community has a civil legal need that will go unmet. And when we talk to people experiencing medical debt, what we know qualitatively is that they prefer trusted community support over the assistance of a lawyer. So at I4J, we're also very interested in not just the justice gap, but the justice awareness gap. So 1 in 3 households will experience a legal problem this year. Only 9% of them will identify that problem as legal. The world of legal innovation is really driving interventions and solutions way up here to people who come to lawyers and courts to say, hey, I have a legal problem. We're trying to get upstream and reach people who are experiencing a human problem that they haven't identified as legal in the justice awareness gap. Some of the barriers to entry we anticipate seeing from the nonprofit sector is that first, we aren't building regulatory reform spaces with nonprofits in mind. Most of the decision makers are judges and attorneys, and we have not done a very good job of including outside voices who could speak from outside the legal profession about the low income, the civil legal needs of the low income population. We're also really focused on market-driven innovation, which makes sense, but that's not a motivating factor for the nonprofit sector. And so what we're seeing in early regulatory reform efforts is basically just legal sector players taking advantage of sandbox opportunities to nibble around the edges of how they provide legal services. So I4J is in the sandbox to bring the A2J. And with that in mind, this is how we framed our challenge that we started last fall, which was to try to leverage the sandbox opportunity to legally empower people experiencing medical debt. We chose the topic of medical debt because debt collection is the most common type of civil case in the US. 60% of the civil cases in Utah are debt collection, and 36% of those are medical debt. So it is the most common type of debt collection in Utah. Medical debt is a leading cause of foreclosure and bankruptcy. And there's a racial disparity when it comes to debt collection judgments. Community of colors experience those at double that of mostly white communities. But we also saw a tremendous capacity for change. When we pulled court data and looked at what happens in medical debt cases when attorneys are involved, we saw some pretty significant levers. So when an attorney is involved in the case, the amount of the eventual judgment decreases by 50%, and the likelihood of garnishment decreases by 69%. Meanwhile, the dismissal rate increases from 19 to 53%. So we know that if we can train non-lawyer advocates to pull the same levers that lawyers pull, there really is a potential here to change outcomes in medical debt cases. This is the design and systems thinking framework that I4J uses, and I'm going to just talk through how we designed the intervention for this project using this framework. So at the empathy stage, everyone on the research team first just navigates the experience of medical debt from the perspective of a person experiencing medical debt. We observe debt collection proceedings. We do a landscape review looking at the existing qualitative and quantitative research, pulling the court data and analyzing it. But then we do a lot of community interviewing. In this project, we talked to 18 people who had experienced medical debt, 30 different individuals and organizations from the nonprofit sector, 14 subject matter experts from the legal profession, the 2 primary healthcare providers in Utah, both of whom are nonprofit hospitals, as well as 4 other healthcare providers, and then 5 subject matter experts from the health law field. Once we do all of that interviewing and exploration of the current status quo, we try to unpack what we've learned. So we're looking to aggregate the information and start identifying the forces at play in the system, both that can undercut the capacity for change, places where we would not want to embed an intervention, but also the bright spots that might be able to be leveraged to drive change toward reducing downstream consequences. This is what the classroom looks like. At the define stage, you can see we're doing some systems mapping and talking about like the flow of issues within the community. And some of the things we learned when we unpacked all of those interviews was first, our lived experience experts said that, and this I think is not particularly surprising, their medical debt is happening at a time when they are experiencing many other life stressors. So they have very little capacity to resolve their debt. They want help, but they're not receiving it. Financial need is actually one of the highest civil legal needs identified in the Utah community, but also an area where legal services are providing very little assistance. So some people experiencing medical debt are trying to self-help. Some just aren't even looking for resources. No one is finding the resources that are available. And generally, they're not thinking to look to our justice system as a place where they can go for help. Also not surprising, we heard a lot of reports of the negative and devastating downstream consequences that people are experiencing after they incur medical debt. We also talked to stakeholders in the system. The nonprofit sector in general said, yes, we encounter people with medical debt all the time and we don't know what to do. We don't know how to help them. We don't know where to send them. Attorneys who are working with medical debt defendants said that they do see valid defenses in these cases, and also that they know that people experiencing medical debt are not going to be able to self-represent to assert those defenses. Attorneys who represent creditors are interested and willing and working on problem solving out of court, but they feel they experience a communication barrier when it comes time to try to engage with people experiencing medical debt. And judges that we talked to said the court is probably too late of an intervention point because defendants aren't showing up and the rules are very rapid and rigid. Judges feel like there's very little they can do. So from there, we think creatively around lots of ideas we could try using what we've learned. This is what the classroom looks like at the point of ideation. So we took hundreds and hundreds of ideas go on the board. We do some assumption testing to narrow that down to 3 ideas that move forward into prototype and test. So the 3 ideas that we tested for this project, the first was to embed a medical debt diversion program. So just before medical debt goes to court, routing would-be defendants to financial advisors, debt counselors who are not lawyers but have specialized legal training to give legal advice and try to negotiate and problem solve the debt. The second idea was to train community healthcare workers to embed medical debt legal advice in their services. So this is a much further upstream intervention. Community healthcare workers are already interfacing with the low-income community around a lot of healthcare related issues, very likely to interface with someone at the time they receive their first medical bill. And then our third idea was to train Bachelors of Social Work students to graduate with a credential that would allow them to give limited scope medical debt legal advice in the course and scope of their social work. And this is because a lot of these students then go on to become frontline staff at nonprofit services. So how we prototype and test ideas in the field as a virtual lab. Prototyping is just creating a really visual representation of an idea and then revising it based on community feedback. So we created storyboards of the experience of working with a person when a person experienced medical debt works with a community-based advocate, and we asked lived experience experts and other stakeholders to walk through these scenarios and give us feedback on their reactions to what it would mean to work with a non-lawyer to problem solve medical debt. Based on that testing, what we heard from creditors is that, yeah, they would work with non-lawyer advocates, particularly if it was involving out-of-court low-cost resolution. People experiencing medical debt think lawyers are scary, but they did respond positively to the idea of having legal advice from a community-based non-lawyer advocate, as long as that person had some form of identifiable certification. And then potential candidates for the medical debt legal advocate pilot did feel when they navigated the prototype, they felt confident that could be trained and provide limited scope legal advice successfully. We also talked to a few nonprofits who were interested in the sandbox projects, but had some real barriers that they were experiencing. One is that they all feel overtaxed and under-resourced. And the idea of trying to get into the sandbox feels pretty overwhelming. They've also been, for a very long time, not giving legal advice and training all of their employees not to give legal advice. So to flip this mental model on its head and think differently about services feels pretty overwhelming because they're worried about legal liability. They also were concerned about the data reporting requirements of the sandbox. They're used to collecting and reporting data for grants. What they don't want to do is have to change their case management systems and do new forms of data collection and reporting. So we're working with those partners to alleviate those barriers. We help them with grant writing. We've designed a training curriculum for medical debt legal advocates that's modular and online and bilingual. So it's really meant to meet advocates where they're at and train them in the course and scope of the day jobs they're already working. We're helping them connect with liability insurance providers, and we're trying to decode the mystery of the sandbox by creating a user-friendly manual that explains what the sandbox is, how you get in it, and how you report data to it. So after we tested these 3 pilots, we found that the medical debt diversion program was very well received. We wrote an application to the sandbox that was approved in May, and our community healthcare worker pilot was also approved by the sandbox in May. But when we started working more on the details of training social work students to provide limited scope legal advice, what we found was that there are a number of administrative and bureaucratic hurdles that we have to do a lot more exploring on. So that project is still in development and will likely have a major pivot before we put any resources into it. If you want to know more about this project, this is where our preliminary findings are located. And if you, there's another slide about I4J that I'll share later. Chris, give me a minute to stop my share.
Thank you, Stacy. And now I'm going to take over the slides. And before I launch into what follows, a little bit of preview, warning, however you want to frame it, that talk about pivot. We're going to pivot very, very starkly away from I would say the core work of I4J, which is that framework that Stacy talked about, going from the empathy stage to the prototyping stage and putting things out into the world to where my strengths come into play, all about evaluation. I'm a trained empirical legal evaluator, and for the last 5 years or so, that evaluation methodology has been exclusively the randomized controlled trial. Everything that I do, I try to do according to a clinical trial. If you think about what the FDA has been doing very recently, is continuing to do as we look to booster shots and expanding the age group of people who can get vaccines, all of it is done through a straightforward randomized controlled trial to ensure that we're really getting at the causal effects of the interventions that we care about in the cleanest way possible. For this project, we couldn't do that in a full-blown field-based clinical trial. The main reason being the intervention didn't exist yet at the time that we did this work. It hadn't even been approved by the sandbox, much less put into action. Even leaving that aside, though, there's a really good argument to do what we did as a matter of science. And that is to take this into a lab setting, pretend as if the intervention exists, try to get real people to engage with it, interact as much as they can, and see both what they choose to do in a situation that simulates the experience of medical debt, and to gather their qualitative insights into where an advocate would be most useful. This is all done through the lab experimental quantitative methods. I'm not going to go into anything about the math behind it. It's actually quite simple, where the ongoing lab RCT, and it is ongoing because we've done one half of it, and we hope to do the second half by the end of the calendar year or early 2022. The main part of this RCT is to take consenting participants and randomly assign them to 2 groups. One is the treated group and the other is the control. The control group in the simulation of what it's like to get hurt, go to a hospital, receive a bill, and then start to receive notice from a debt collection agency all the way up to a lawsuit. They go through this experience without any possible access to a legal advocate or to a lawyer. They're going through it completely on their own. The treated group has the opportunity to talk to a medical debt legal advocate, an MDLA, but we were really curious to know what about the presentation of the MDLA, at what decision points in the medical debt experience would people actually, quote unquote, listen to the MDLA. So advice here is going to be static, it's going to be pre-programmed, and it's also something that the participant can choose to listen to or not. The other part of this study is to get at something that I'll only briefly mention, which is to do this well, it often requires that you dive into this forum called MTurk. It's run by Amazon. It's a service where there are people who are signed up to be platform participants. They get paid according to what the researchers are offering and what MTurk provides to be these survey participants. There's a lot of questions about whether results from MTurk are generalizable, if they would look like what you would get if you had the ability to go out into a community and recruit your own participants. So the second half of the project is going into Utah and actually making connections with community partners, and they're bringing potential participants to the study. The half that's been done already is all MTurk based. This is one view into what a participant has seen on MTurk. I will at least play a little bit of what this looks like so you can get a sense of how this worked.
Hi, I'm Taylor. I've heard that you've been sued because of some medical bills.
I just want to make sure the sound is coming through okay.
Be your advocate in the process. I can offer free legal advice about and assistance with your medical debt issue. Just to be clear, I am not an attorney, but I have been trained and certified to provide legal advice and assistance. I can help you understand your options and choose which one is best for you. I can also help you understand how things work at the court, help you complete and send in court forms, and help you prepare for your day in court. Remember, I don't charge anything for giving you advice. I am helping you for free. Hi, I'm Taylor.
So that is an example of what a participant in the experiment would see. There are a bunch of these videos. There were static text pages that just gave them information and asked them to make certain choices. So when that happened, we would then ask them to do things like what you see on this screen. When the person experiencing medical debt in the simulation is told that a lawsuit has been filed, and now they're at the negotiation stage with the plaintiff, who we call here med debt, with or without Taylor the advocate, they're going to be asked, how much do you want to offer today as a starting point to try to build down the amount that's owed? And also, how much are you willing to pay on a monthly basis starting next month? And zero was an option. To note here, in the simulation, we told people that they have $500 of savings right now. And given their expenses and how much they earn, they would be able to set aside an additional $100 per month going forward. And here are some preliminary findings from the MTurk version of this experiment. These are super preliminary. Please don't cite to any of this. And I'm not doing anything about statistical inference. This is all just descriptive from what our MTurk respondents had to say. So there are an equal 56 control and treated cases. The randomization, for those who are curious, is done within Qualtrics, where the simulation lives. And so it has an algorithm in the behind the scenes that randomly sorts people into control and treated. Of the 56 control cases, very helpfully for this work, 54 of them, which is 96%, would have wanted to work with an advocate. They're asked about this after they go through the whole simulated experience of medical debt. They realize how little they know. I've heard from some of our test participants, even people who are highly educated, in some cases are lawyers, in other cases have never experienced medical debt, to be sure, they find this stressful. They find the pummeling of information and the concern over what can happen if you end up experiencing medical debt to be pretty stark. And our MTurk population, almost all of them who did not have any possibility of hearing from Taylor the advocate, would have wanted to hear from an advocate. 24 of them, which was a plurality of the options, when asked what type of advocate they would have wanted to work with, they were given the options of a social worker who is from United Way, our MDLA-esque advocate that looks a lot like the I4J prototype, and then a neighbor who's gone through the medical debt experience. Most people in this control group chose the MDLA-like advocate. And then we also were curious, among other questions, if you had the opportunity to engage with an advocate, what's the first time that you would want to start working with one? The earliest option was when you actually check into the hospital before services are even rendered there. Not a lot of people were interested in that early in the process, but a full 86% would have wanted to start working with an advocate when they first get their bill, forget actually making any payments on it, or when they get their first notice from a collections agency. Both of these are, of course, before service of process is completed, before a lawsuit has necessarily been filed. Heartening to know that if we're trying to make this a preventative solution to the medical debt issue, 86% of people would be interested in working with an advocate at those early stages. Interestingly, though, and you'll see this replicated in the treated cases, among these control participants, most people nonetheless, when asked who they would trust the most to give them legal advice, 28 of them said that they would choose a lawyer first. There we are. The first choice of a non-lawyer legal advocate was the first choice of 19 respondents. So not terribly far from the lawyer perspective, but lower. Only 19 had it as their first choice. I don't know yet quite what to make of this. I'd be very interested to know, and when we do our MTurk versus community-based respondents, whether this changes. It could very well be that the population of MTurkers, even though we tried to make it as close as possible to the target population in Utah, they could be significantly different and actually want to hear from a lawyer for legal advice. Nonetheless, it's heartening that even 19 had the legal advocate as the first choice. Now, on to the treated side. 47 of the 56 treated respondents wanted to hear from Taylor the advocate the first time that they had the opportunity to do so. I expected, based on some earlier rounds of beta testing, that this number and percentage would be lower, that actually people would want to just fly through the experience, even though they had the opportunity to get helpful advice from Taylor, but 84% wanted to hear from them the first time. And then almost all of them, 44 of those 47, after hearing the first thing that Taylor had to say, which was an explanation of what the summons is, also wanted to hear from Taylor about the negotiation process. Again, of the 56 treated cases, a plurality this time, instead of wanting to work with the type of advocate that they did work with, 24 or 43% would have chosen, if they had the choice, to work with a social worker-like advocate. Just under 30% would have chosen an advocate resembling the MDLA that Taylor was. Then when we get to the question of when the advocate is best timed to make contact with a person who might experience medical debt, 64%, about 2/3, would have also said upon receiving the first bill or receiving a letter from a collections agency, keeping in mind that of this group, they didn't hear from Taylor until they were actually served with a complaint and a summons. Most people in the treated group, again, thought a lawyer would be the most trustworthy person, and 21 ranked a non-lawyer legal advocate as the most trustworthy. No other type of potential source, whether it be themselves, whether it be a friend who's gone through medical debt, anywhere near the numbers here. The overwhelming support from both the treated and the control cases were for either a lawyer or a non-lawyer legal advocate. Now, this will have a lot of numbers thrown at you, and then we've got the concept of the median and the mean as a little bit of a refresher. The median value here is the one that splits the group completely in half, whereas the mean is typically what you think of as the average. So among the control group participants, half of the control group offered $250 at the negotiation, and the other half offered something less than that. And the mean is slightly less at $226. The reason for this difference is that there are a lot of $0 offers in the control group. That's what makes the mean and the median differ this way. Then I had to split out, because I thought there were going to be interesting differences, the median for the treated group, but who ignored Taylor's advice on what to do with the negotiation. Their median was lower at $225, and the mean was $197. What you're thinking about here, of course, is, again, with $500 in savings now, their first offer was $25 lower than the group that didn't have any opportunity to talk to Taylor. We can discuss whether making a higher offer makes more sense. Some people might think that with $500, you should offer more to try to pay down as much of the debt as possible. Others might say it's better to save and see what can happen down the road, but they offered less. The median treated group that did listen to Taylor's advice looked a lot like the group that didn't have any access to Taylor. A median offer of $250 and a mean of $222. So what do we make of these differences? There will be some thinking that we do, especially compared to the Utah community-based partners group. My guess here is that the group that was randomly assigned to the treated condition and had the opportunity to listen to what the advocate's advice was, but chose to ignore them, that's a pretty specific group. This is a group that may be more risk averse, may be a lot more independent, clearly, by not wanting to hear the pre-programmed good advice from Taylor, and might then offer slightly less, both in terms of median and mean. It's hard to say yet whether we should draw any inference in the fact that the control group and the treated listen to Taylor group are functionally the same. It could also just be that this is a pretty straightforward task they were asked to do, and most people are going to default to half of what their savings are as an anchor point, no matter what happens. All right. I'm going to actually let Stacy take it over from here, because this is what we hope to do down the road.
Sure. So let me find slides. Can you just put the slides back up, actually? I think there's just a couple of them. So, really the goal for this research project is to produce some actionable research. And so right now we're working with 5 nonprofit partners. We have the 2 approved sandbox pilots. We are working to fund those and get them running in the field so that we can evaluate how those advocate services are provided in the field and the outcomes that advocates, non-lawyer advocates, can deliver. We're also working with those partners to make sure they're equipped to operate in the sandbox. And the ultimate goal, after we fund, launch, and test these pilots, which we're also doing in Arizona with our LA pilot, is, I think on the next slide, some like wonky slide nuts. Yeah, so, ultimately we're hoping to create a generalizable and replicable strategy. It's kind of a long day for me here. That really informs conversations about nonprofit resource limitations, knowledge gaps, and liability concerns, and the strategies for overcoming those barriers, so that as regulatory reform moves forward, we see not just market-driven innovation taking advantage of regulatory reform, but the nonprofit social service sector that has historically been excluded from providing legal advice and whose clients have turned to our traditional models of legal aid and pro bono for services. If you want to know more about I4J, this is our website, and thanks so much for your time tonight. We're happy to stick around if anyone has questions.
If you have questions, you can pop them into the Q&A feature, or if the raise hand is open to you, you can use that, and I will actually let you go live with the question. Stacy alluded to this earlier about the evaluation component to stuff that I4J does, and I want to take the opportunity to thank Stacy for embracing evaluation as much as she has. It's not easy all the time, although the access to justice community is unfortunately still relatively small. We've seen in this series how many people just in the Pac-12 universities, law schools are doing this work. There's not a lot of attention paid to evaluation. And I know that I'm biased about that, but like-minded colleagues and I really do believe that if we don't do this evaluation work, then we're missing an opportunity to really prove to the world that our innovative ideas are moving the needle. And any opportunity I have then to work with Stacy and I4J to put that into practice is a welcome one. So thank you, Stacy, for all that.
Thank you, Chris, for all you're doing for I4J since inception. I think we're so thorough, we don't have questions.
I guess so. I mean, this happens a lot to me, and I never know whether it's because it was completely inscrutable or boring or both, or we covered everything quite
thorough
well.
And riveting.
Good. Well, thank you all for coming tonight and watching along, and we'll see you at the next Pac-12 event. Take care.